everyone. Thank you for taking time to join us today. So today's clinic is really intended to give you an idea on what to expect if you apply for Social Security benefits, how to apply, and how Social Security makes its decision. So first off, just some little bit more about us. So we are Legal Aid of North Carolina. We are a statewide nonprofit law firm that provides free legal services to low-income people in order to help them access justice. We only provide representation in civil matters, so we don't do anything involving criminal court or traffic matters. In particular, we handle issues involving housing, employment, education, domestic violence, disaster relief, and consumer work. So we have these monthly listen and learns for a variety of topics, and I encourage you to come back and join them if you're interested in learning more about any of these areas. One more that I'll add that didn't make it onto the list is our SNAP 101 clinic that I do, and it involves food stamps, your rights, how to apply. So if you're interested in any of these, please definitely sign up or watch the recordings that are available through Facebook. So let's talk more about Social Security disability benefits. So broadly, there are two different types of disability benefits that you can apply for from the federal government. The first is called Social Security Disability Insurance, or SSDI. This program is based on your work history. In particular, they look at what are called your FICA taxes, your Federal Income Contributions Act taxes. These automatically come out of your paycheck every week or month to go towards the federal government. You have to have enough of what you paid into the system in order to be eligible for SSDI. So you have to have 40 credits to be eligible for SSDI. A credit is equal to 1 quarter or 3 months worked, essentially. So you have to have 40 credits to be eligible. 20 of those credits must have been within the last 10 years before you became disabled. So if you have never earned 40 credits, which equals about 10 years of work, or if your work history was in the remote past and you've been out of work for several years before you became disabled, you might not be eligible for SSDI. The alternative for folks is called Supplemental Security Income, or SSI. This program is based on disability as well as need. They don't look at all at work credits or your work history as far as how much you get in a monthly benefit. This program, though, does have income and asset limits. So the income limit would cover things like earned income if you are still working on a part-time limited basis while receiving SSI, or unearned income if you receive another type of cash assistance, or if you are married and you have a spouse who works or receives some sort of benefit cash assistance program. There are limits to how much income you can have and still receive SSI. There are also asset limits, which are $2,000 for an individual or $3,000 for a married couple. There are a lot of exceptions, though, to this limit, including your home, one car that you drive, some different life insurance policy exceptions. So it is a little bit more broad than just $2,000, but it has those income and asset limits. For SSDI, which is based on your work history, the amount that you receive every month depends on how much you've worked, how much you paid into the system. There's everyone to use SSDI. For SSI, there is a maximum, which for 2023 is $914. That's the most that anyone receiving SSI can get each month. And for some folks, it's less than that if they have income from other sources. So one thing a lot of people aren't aware of is that children can also be eligible for disability benefits. It's not just adults. For children, there's a different disability standard. When we say children, this means people under 18 or under 22 if they're still a student in school full time. So because they're children, whether or not they're disabled is not based on their ability to work, but it is based on several developmental areas. So Social Security will look at how the child functions in these developmental areas relative to other kids their age. And if they have significant impairments in these areas, then they can be found disabled. So specifically, Social Security is going to look at the child's ability to learn and use information, attend and complete tasks, interact and relate with others, fine and gross motor skills, self-care. What matters is the total effect of all of the child's conditions on their functioning. So the child might have several different conditions that all together make them disabled. Children in this regard are only eligible for SSI, which, if you remember, is the one that is based on need, not based on work history. And children would still be, liable or responsible for a continuing disability review would still happen in their case. So just because they receive disability benefits as a child, it doesn't mean that they're going to receive disability benefits for the rest of their life, especially because with children, they grow and they change. So a child might meet these requirements to be disabled at the time, but in a couple of years, Social Security will review their case again to see if they still meet all of the disability requirements. So there's a helpful tool here available on the Social Security website called the Benefits Eligibility Screening Tool that lets you see what benefits you might be eligible for. Importantly, these answers are not recorded and they're not going to be used against you. When in doubt, so if you're not sure whether you should apply for SSDI or SSI, you can always apply for both and just see. There's no penalty to applying. If you're not eligible, Social Security will simply tell you you're not eligible. So for adults, the definition of disabled that Social Security uses has 3 specific requirements. So the first is that you must have 1 or more severe health conditions that will last 12 months, at least 12 months, or more, or result in death. Secondly, you can't do the type of work that you used to do. And then lastly, you can't adjust to doing any other substantial work due to your condition. And we're going to talk about what substantial means in just a minute. Social Security uses what they call the 5-step sequential analysis to determine whether or not someone is disabled. When they say sequential, they just mean that you go directly from step 1 to step 2 to step 3 and all the way down. It's very linear. So the first question they ask is the claimant, which would be the applicant, the person trying to get disability, is the claimant engaging in substantial gainful activity? If the answer is no, they go to the second step, which asks, well, do they have a severe impairment or combination of impairments that meets the duration requirement? Which, remember, again, is at least 12 months or resulting in death. Third step is, well, do they meet or equal one of the listings, which are a very specific list that Social Security has made of certain disabilities to where if you meet the specific requirements, you are automatically disabled at step 3. If you don't meet one of the listings, you can still be found disabled. Social Security would then go to step essentially 3.5, which asks, okay, then, well, what's your residual functional capacity? Which means when all of your impairments are taken into consideration and all of your limitations are looked at together, what is the most that you can still do? Once they determine what that is, they go to step 4 and says, okay, so given that what the most you can do is all that you can do, are you still able to perform your past relevant work? If not, they'll go to the last step, which asks, okay, well, can the claimant, given their conditions, make an adjustment to other work that exists in significant numbers in the national economy? If no, that person is going to be found disabled. So you can be found disabled at step 3 if you meet or equal one of the listings, or at step 5 if you can't do your past work and you can't adjust to other work. So substantial gainful activity is a really important topic in Social Security law. So it means earning more than $1,470 per month. That's the 2023 number. It changes every year based on inflation. So if you are earning more than $1,470 a month, Social Security is going to automatically decide that you are not disabled. It doesn't matter what your impairments are, what your age is, anything like that. If you're making more than $1,470 per month, you are not disabled. The only exception that I will flag for this is people who are legally blind. This number is different for those folks. But for all other impairments, the number for substantial gainful activity is $1,470 per month. And this is before anything is taken out for your taxes. Let's talk some more now about what a severe health condition is. So this is very broad. Again, it must have that durational requirement of lasting at least 12 months or resulting in death. You can meet a listing with your severe condition, so you meet the specific requirements. If you don't, they will move on to whether you functionally meet the listing, so you don't meet it exactly, but you're close enough, and taken all together, you're as disabled as someone who meets a listing. If that doesn't happen either, they go on to, can you do your past work? Can you adjust to other jobs? So really, severe health condition is any health condition that has some sort of significant impact on your job. It doesn't have to happen every day, but if it does have more than just a minimal impact on your daily life or on your work, it counts as a severe impairment. When Social Security looks at your ability to work, they consider your age, your education, your work history, your residual functional capacity, and whether you can be trained for any other jobs that exist elsewhere in the economy. So first, let's go back to age and education. So generally, the older someone is, the easier it is to meet Social Security's standards and rules. The less educated someone is, the easier it is to show that someone is disabled. So the older someone is, or the less educated they are, the easier it is to show that they are disabled. And that's because there are just limited job opportunities available for people with limited education and an older age. Work history is also really important. An example that I always give to help explain this is if you think about someone who has worked a very hard manual labor job their entire life, and now they're mid-50s. If they've done construction their whole life and they're mid-50s now, maybe they're not able to do heavy manual construction anymore. Maybe they physically could do a job where they're sitting down all day, but if they're in their mid-50s, they have a limited education, they've never done a sit-down job before. Social Security recognizes that people in that situation are going to have a very difficult time trying to find a sit-down job. So if your work history matters significantly. And then lastly, where it has anywhere in all caps, that's just to point out to everyone that it doesn't matter what the job market is like in your particular area. That's not something that Social Security considers. They look at the national economy and what jobs are available across the whole country. So just because there may not be job openings in your town, that's not something that Social Security is going to consider. They also don't consider things like a lack of transportation, a criminal record that makes it difficult for you to get a job. Those kind of things that are particular to your situation are not things that Social Security is going to take into account when they're looking at whether you can find other work. Okay, so a little bit more on residual functional capacity. or as I like to say, the most that you can do with the physical conditions that you have. So you can have what they call exertional limits and also non-exertional limits. Exertional limits focus on limits in your physical strength. So these would be limits in your ability to sit, stand, walk, lift, carry, push, and pull. Those are exertional limits. But there are also non-exertional limits. These are physical and mental limits that restrict your ability to function, but they're not really incorporated in those 7 basic strength demands. So these could be postural limits. So if you have difficulty climbing stairs or stooping, which is a word that Social Security really just uses to mean bending your back. That's what they call stooping. You could have manipulative limits. So if you have a hard time reaching with your arms or handling small objects with your hands. Visual limits, communicative limits, so difficulties with your hearing, speaking, or understanding. Environmental limits, if you can't be around noises, fumes, hazards. And then also mental limits. So this could be limits in your ability to understand information, remember instructions, respond appropriately to other people in your work environment. And Social Security has to take all of these limits into account. Every single limit that you have that's caused by all of your different physical or mental conditions have to all be incorporated into your residual functional capacity. If you want to apply for disability, you have a couple different ways to go about it. You can call this number here, 1-800-772-1213. That is the 1-800 number for Social Security nationally, and they can give you information on how to contact your local office. You also can, you can go into your local office and tell them that you want to apply. They're generally going to require you to make an appointment because it does take a while to go through this process. And so it might not be the same day that you go in. You can apply over the phone. You can mail in an application. There are certain applications that you can do online. So if you want to apply for SSDI, which is the program based on your work credits, you're welcome to do that online. There are certain SSI applications that you may be able to do online. I've never been able to do one online. It just hasn't worked out for anyone that I've tried to help with it. I generally recommend that you do it over the phone or go into your local Social Security office if you want to apply for SSI. Remember too, you can apply for both. If you're not sure whether you should do SSDI or SSI, do both to protect your rights. You will have to complete an application and give them information on your disability, as well as signing a release form for Social Security to get your records from your doctors, hospitals, because they really want to see what's in your record to make sure that everything in your medical record supports what you're saying. It's helpful if you can give Social Security as much information as possible about your medical providers. So they're going to want to know the name of the doctor's office you go to. When was the last time you went there? When did you start going there? How often do you go? Do you have their address? Do you have their phone number? If you don't have those things, you can still apply. I don't want that to discourage anyone. But if you want to have a smooth application process that goes a little bit quicker, it's helpful for you to have all of that information together before you start the process. Your doctors will then send your records to Social Security. It can be helpful for you to follow up with your doctors to make sure that they did get the request from Social Security and that they did submit them. So as many of you have probably heard from loved ones and folks in the community, applying for disability can be a very complicated process, and that's because there are multiple different levels. So the first level is the initial decision, and that's made by a group called Disability Determination Services, or DDS, based out of Raleigh. They will look at your application and your records, and they'll make a decision about whether or not they think that you're disabled. If they deny your application, you have a right to appeal. And at this stage, an appeal is called a request for reconsideration. Essentially, your application with your medical records goes to a different person at DDS, so a different person within the same agency, and they make a decision whether or not they think that you're disabled. If they still deny you at this stage, you can appeal again. At this stage, it's called a request for a hearing. At this level, it does not go back to DDS. It goes to a federal administrative law judge at your local Social Security hearing office. This is the first step in the process where you have a right to a hearing, where you can go, you can talk to the judge, you can give them more information and testimony about your symptoms, you can answer any questions that they have, and then they'll make a decision on your case. If the administrative law judge also denies you, you can appeal again to the Appeals Council, which basically is a level still within Social Security that reviews decisions made by administrative law judges. At this stage, they're not really looking at facts anymore. They're looking at whether the administrative law judge properly applied the law. So these are going to be legal appeals. So whether or not your administrative law judge appropriately applied Social Security law. If the administrative law judge denies you and the Appeals Council denies you, you can file what they call a complaint for judicial review, which goes to a federal court judge who makes the final decision. And then you can see at the chart, it shows the different levels to which people are generally granted or denied. The initial level has a very high denial rate, as well as the reconsideration level has a very high denial rate. Administrative law judge, it gets significantly better. So I generally want to tell people that it's better to appeal your process than start over. So if you get denied, I don't recommend that you just file a new application. You have a right to do that, but I would say it's better to appeal and continue the process. And I'm going to take just a minute to drink some water. Bear with me here. Okay, thank you. So what is Social Security looking at when they start reviewing your claim? So it's going to go to a claims examiner at Disability Determination Services. They're going to look at all the eligibility requirements. So do you meet age, employment history, medical status requirements for SSDI, as well as the additional assets and income limits for SSI. They will look at medical records, your doctor's reports. They might ask you some more questions. They might send you paperwork, asking you questions about your daily life, wanting information about someone else they can talk to, like a family member or a friend who knows your conditions. They also commonly send people to what's called a consultative exam, which is a doctor's appointment that Social Security arranges and that they pay for, where you go and you talk with this doctor about your conditions and they can do some tests. So again, your initial claim is denied. You'll get a written notice in the mail that says that you're denied, and it has your appeal rights on it as well. You have 60 days to appeal. The 60 days start the day that you receive the letter from Social Security. If you want to appeal, you use the request for reconsideration form, and you also need to provide updated information on your disability. You would need to do another authorization to disclose your medical records to Social Security, and You can do the appeal in a number of different ways. You can go to your field office and they can give you the paperwork. You can print these forms online and take them or mail them to your field office. You also can do the appeal itself online and get a confirmation showing that it was received. If you're denied again at reconsideration, it's the same steps to appeal. You have, again, the 60-day deadline. This time, though, you use a different form that shows you're requesting a hearing before an ALJ. Again, you can do this online as well. You'll have a hearing. It's generally here, it says 12 to 20 months from when you appeal. I think that's probably accurate. The hearings can take a long time, so people really should be aware that it's probably going to be at least a year of waiting, unfortunately. You do get notice at least 75 days before your hearing so that you have time to schedule it and make sure that you're available then. You can choose whether you want an in-person hearing, a telephone hearing, or a video hearing via Microsoft Teams. The in-person hearing, there's a good chance it is going to take longer than your telephone or your video hearing just because of the backlog from cases that couldn't be heard in person during the pandemic when the Social Security offices were closed. So if you really want a quicker hearing, telephone or video might be the best option for you. But if it's really important for you that the judge sees you in person, you do have a right to say that you want an in-person hearing and to wait for the hearing. A lot of people ask, should I get an attorney? And that's really up to you. Most people who get a private attorney do so after their reconsideration denial because the denial rates are so high already at initial and reconsideration, and you don't have a hearing at those stages. But when you're getting ready for your ALJ hearing, it can be really helpful to have an attorney who understands the system and can help you advocate for your case. These attorneys generally are paid on what's called a contingency fee, which means that you don't owe them anything unless you win. If you win, though, they will take a percentage of your retroactive benefits. These are the benefits that go back to when you applied. They might not necessarily go back that far, but it's benefits that you should have been receiving if Social Security hadn't previously denied your case. So when you win, you get a lump sum award of your back benefits, and then you get monthly payments going forward. Your attorney can get 25% of your retroactive benefits up to $7,200. So they can't take more than that. That's set by law. But up to that, they can take 25% of your benefits, which usually don't even come to you. They go straight to the attorney. Like I said, the ALJ hearing is the best opportunity to be approved. That's why it's so important to appeal, to do so within the deadline, and to make sure that Social Security receives your appeal. You want to have all of your medical records and evidence into the judge before your hearing so that they can review everything and make sure that it's complete. It's also helpful to get a statement from your doctor. If you have a good relationship with your doctor, they might be willing to write a note explaining your conditions and your limitations. Some people also decide to get in touch with vocational rehabilitation, which is a state agency. They can assess your skills. They can do job training, job recommendations, just to see whether or not you can work. It's up to you and whether you want to pursue that, but some people find it helpful. So the administrative law judge hearing itself is going to be held at what's called a Social Security Office of Hearings Operations. So this is not, generally is not the same as your local Social Security office that you would go to apply or talk about a question with your payments. This is a particular hearings office. There's not one in every county. There's usually just a couple in each state. They don't require you to travel more than 75 miles from where you live, but that said, it may still be, 50 miles from where you live. That's something to take into account when you're deciding whether you want an in-person hearing, telephone, or video, is whether transportation is going to be a difficulty for you. If you do decide to do an in-person hearing, definitely recommend being early just to make sure that there are no issues. When you're testifying before the administrative law judge, you have to be honest. It's very critical. You're testifying under penalty of perjury, and so you're asserting that it's true. Your judge is also going to have your medical records. So if you say something that's not in your medical records, the judge is going to know. And then they might not believe what you say if it doesn't match your records. So definitely be honest, be specific. Vague answers can really hurt a disability case. For example, if I ask a claimant, what's your pain like? And they say, oh, it's really bad. That's vague. Really bad can mean different things to different people. It's more helpful to say, oh, my pain is an 8 out of 10. It's shooting and stabbing. I can't stand for more than 15 minutes. I toss and turn all night. Like that helps the judge understand what it's like, because the judge needs to understand your day-to-day and your symptoms in order to make the decision. Again, submitting all medical records is crucial. You or your attorney, if you have one, has a duty to submit all medical records that you're aware of, even if it's not good for your case, because you have to submit everything. You definitely don't want to look like you're hiding something. And judges are really good at figuring it out. If they think that you're hiding something or lying about something, it's better to be upfront about it so that you can disclose it and then move on. You should submit these records at least 5 business days before the hearing, if possible. And you want to provide records about your educational background. If you were in special education or had any accommodations in school, those can be helpful. And the judge is going to ask you, how far did you go in school? Do you have any licenses? Anything about your education. The judge is also going to ask you about your work history for the past 15 years. So they're going to want to know about every job that you've had at that time. These questions can be tough for people who have worked a lot of different jobs or worked for a short period of time at a job. So you want to just try to answer as best you can. They're going to want to know how long you worked at each job, why you can't do that job anymore, what you did at that job, why you left. This is another case where you want to be very specific, because remember, your work history plays into whether Social Security thinks that you're still disabled. They're going to ask you about any medications that you take, as well as any side effects from those medications. You want to tell the judge if you have any prescribed medical equipment that's been prescribed to you by your doctor. This could include cane, walker, braces. The judge is going to ask about your daily activities, how you feel, what you can and can't do, what you need help with and why. And you do have a right to also bring witnesses with you to your hearing. So if you have a caregiver who helps you, that could be a great person to testify about your limitations. The hearing decision, so this is 2 to 3 months after the hearing. It really just depends. Some decisions come out within a couple weeks. Some decisions come out within 2 to 3 months or even longer. It really just depends on whether or not there are any medical records that are still outstanding at the time of the hearing. And it just depends on the judge themselves and how busy they are, what their schedule looks like. You will get a written decision, though, in the mail that has a summary of the facts from your case and your medical records, your testimony, as well as the judge's decision. If they think that you're disabled, it'll tell you the date that you became disabled, which is important to determining how much back pay that you get. And if you're denied, you can appeal to the appeals council. You have a 60-day deadline to do so. At this stage, you really do need to consult with an attorney, because remember, this appeal is about errors of law It's very legal. It's helpful to have an attorney at that level, if not before. If you do receive benefits, there are a couple of different things or issues that can come up that I just want to flag for people. So the first is age 18 redeterminations. So this happens when a child has been receiving SSI under the child standard. Once they turn 18, Social Security automatically reevaluates all of those cases to see whether the child meets the adult standard. Because remember, the child standard is about whether or not the child has impairments relative to other kids their age. The adult standard is all about, can you work? Are there jobs that you can do? So a child might be disabled under the child standard because they're delayed compared to their peers. But if they turn 18 and they can still work, they're no longer going to be found disabled. There's also continuing disability reviews. These happen, generally it's like 3 to 7 years. It depends on the person. But if you're found disabled, Social Security will review your case 3 to 7 years. And when that happens, they'll send you some forms, ask you to provide information about your doctors. They'll look at your case just to make sure that you are still disabled and that you haven't improved from medical treatment. They think that you have improved, they can terminate your benefits. You have appeal rights with that though. So if you receive benefits and you get a notice that you're being terminated from benefits, it's very important to read those letters all the way through and comply with any appeal deadlines to protect your rights. And then the last issue that can come up for people is overpayments. This is generally for people who are receiving SSI, because it's a needs-based program with income and asset limits. So if your income is too high 1 month or your assets are over the limit, you might be overpaid because you shouldn't have received SSI for that month, but you did because Social Security didn't know about the income or the assets, or they knew about it too late. So people can get overpayments. It also can happen if people are receiving disability benefits and they try to go back to work, but they don't follow all the reporting requirements. So it's really important, if you're receiving benefits, that you keep Social Security up to date on your income, your assets, your address, whether you're working and how much you're working, to avoid any kind of overpayment issue. So how do you get help? If you're looking for medical help, if you aren't able to get Medicaid or health insurance, there are several free clinics across the state, and these 2 websites here can help you find one that's close to you. If you are looking for a private attorney to help you with applying for disability or getting representation, we generally recommend the NC Bar Lawyer Referral Service or the NOSCR Lawyer Referral Service. NOSCR is an organization of nationwide Social Security attorneys. Both of those referrals have attorneys that have been vetted, and you can call them to ask for their help with your case. We also have the number here too for legal aid, because we do some Social Security disability work. Generally though, in order to be eligible for our services, you have to have been denied by 2 private attorneys. So if you want an attorney to help you with your appeal, you should contact private attorneys. If you get denied by at least 2, you can call legal aid, and then we'll investigate to see whether or not we can represent you. So there have been some changes due to COVID-19 and the pandemic. So we are doing in-person hearings again at Social Security. For a while, those were on pause, but they are available now. They generally do have a longer wait time though, because of the backlog. Prior to COVID, there was no option for telephone or video hearings. They all were in person. So it's kind of a good result is that now you have the option to choose telephone or video if transportation is going to be an issue for you. One thing though to keep in mind when you're making that choice is technology issues. So do you have a reliable phone? Do you have internet access? Are you comfortable with using Microsoft Teams? Those are things that you want to take into account when you're making that decision. And you can also talk to the hearing office if you have questions about those, or if you change your mind, you can talk to the hearing office. So this slide is just to help increase awareness about the Affordable Care Act. Some people call it or know it as Obamacare. This is a program that offers subsidies to people to help them afford health insurance if they're not eligible for private insurance or Medicaid. We're not currently in open enrollment for the Affordable Care Act, but there are special enrollment periods available. So if you are low income, or if you've had a recent change, like you've gotten married, lost a job, had a baby, you may be eligible to apply now and receive ACA coverage. So I would recommend that you use the phone number or the website here to contact the navigators. You also can apply for Medicaid if you think that you have a disability, even if you haven't been found disabled by Social Security yet. If you're in the process of applying for disability, you can also apply for Medicaid, which would be health insurance through the state, and you would do that at your local DSS office. Yeah, so then again, here is our phone number again on our website, as well as the lawyer referral line. I wish you the best of luck if you are interested in pursuing disability benefits. And I'm happy to answer any questions if anybody has any questions. Again, though, you have to keep them broad and general because I can't give you legal advice on your particular situation. But if you have any questions about anything that we've talked about, please let me know.
People who are on about 2 minutes to put any questions or anything that needs to be clarified, so that way Lainey can address them. This recording will be available on our Facebook page on facebook.com/legalaidnc. You do not need a Facebook account to access those videos. We do have previous topics, including this recording and past recordings of this topic, in our videos tab in our Facebook page. So please be mindful of that. Okay, we'll give it another minute. If you do have any questions in the Zoom, please put them in the Q&A box. If you're watching on Facebook, please put all your questions in the comment section. All right. Well, thank you so much, Lainey, for presenting today. Thank you all for who attended. I hope this information was helpful to you all, and I hope you all have a great weekend.
Thank you.
Thank you.